Self-Petition and Hardship Waivers webinar. This is kind of new to us, very new to us, so bear with us if there's anything that happens glitchy or what have you. But I hope everybody's been well and safe during this time. And without further ado, I'm gonna just give you, we're going to talk a little bit about Her Justice, what we do, who we are. We're talking about our learning program. So who is Her Justice? Her Justice, our mission statement is, Her Justice stands with women living in poverty in New York City by recruiting and mentoring volunteer lawyers to provide free legal help to address individual and systemic legal barriers. We believe that women with urgent safety financial immigration needs deserve legal representation, and therefore we recruit attorneys from large law firms such as yourselves to help us in representing these individuals. And today's learning objectives, hopefully at the end of today's training, you will be able to advise your client and explain the VAWA and/or hardship waiver petition process. You will interview your client and supporting affiants. You'll identify and collect relevant evidence, draft affidavits addressing the required elements, and complete and submit relevant immigration forms to the U.S. Citizenship and Immigration Services. This summer is a little bit different. I mean, so for the past 3 months, our practice has become very different. So I will talk to you and we will go over how to remotely connect with your clients, to talk to your clients and do most of these things remotely, like interviewing your clients, collecting documents, and even signatures and drafting everything remotely with your clients. So don't worry about that. These are still our learning objectives. We've made sure that we are trying our best to make sure that we give you guys best practices in how to do this during this, the COVID-19, the pandemic, and just working remotely in general with your clients. So Her Justice has what we call a pro bono first model. What this means is that we engage the talent and resources of New York City's law firms, bringing together committed lawyers and determined women to secure life-changing results. So we have 13 Her Justice lawyers, staff attorneys, supervising attorneys, directing attorneys, and we mentor about 1,800 legal volunteers, and we serve about 9,000 women and children annually. So this is what the pro bono first model means, is that we basically take our resources and, we tap into your resources to be able to serve as many people as possible here. Okay. And then who are our clients? So our clients are individuals living in New York City who identify as women and whose income is below 200% of the federal poverty line. So next slide is going to be our first kind of quiz, just to warm your brains up a little bit on this Friday morning. I know it's a Friday in summertime, but everybody's home anyway, so let's get going here. And what is the federal poverty line for a family of 3 in 2020? So A, 21,720. B, 36,940. It went a little bit quickly. Mike, I think you threw up hang on, wait, we're going too fast, wait. Okay, so anyways, yes, the answer is A, 21,720. That is the federal poverty line for a family of 3. So even, hang on, even this minimum wage is not remotely enough to support a family as a single parent. And the living wage obviously in New York is a lot higher than that. And so our poverty, what our income level is 200%, which comes up to be 43,440. And even that is really hard for a lot of parents. So, or a lot of single moms or individuals. So that's where our line is, at 200% of the poverty line is where our clients come from, okay, at least. And the next question is going to be, in the US, women are how much more percent likely to be living in poverty? 12%, 38%, or 57%? All right. gonna end the poll. I think most of you have answered so far, so I'm gonna, the answer there is 38%. And this statistic illustrates why we serve women. Poverty remains a women's issue mostly, due to, among other things, wage gap, traditional family, childcare, caretaking responsibilities, traditional lower paying careers for women. And this statistic and those numbers comes from the NWLC Poverty Among Women in 2018. And then, where do our clients live and who are they? Well, our clients are from all 5 boroughs of New York City, and the demographics of our clients are 25% are Black, African American, Caribbean, or African, 55% are Hispanic, 9% white, 8% Asian, 3% Native American or other. 55% of our clients of Her Justice are born outside of the United States, and 2/5 of our clients cannot access the legal system without an interpreter, which means that they are limited English proficient. Okay. And it's unsurprising that most of our clients are women of color, given the US's history of systemic racism. I know there's a lot of talk of that going on in the community right now, and we have been seeing this throughout Her Justice's existence. When we look at the we serve. And it is also unsurprising that we have so many immigrant clients, given the barriers immigrants face to economic security, such as language barriers, discrimination, and aspects of the immigration system that is just almost impossible for a person to navigate without an attorney or without English proficiency or any kind of legal knowledge. And we'll talk about, and of course, this training is to unpack some of that and help you guys to be able to understand and assist a client in navigating that system. Okay. So without further ado, we're going to go into a little bit of domestic violence 101. And this area will also cover how to deal with your clients during, how to represent your clients during this time. And here we go. Domestic violence, 75% of Her Justice clients are survivors of intimate partner violence. Now, 100% of the clients that you guys will be dealing with are survivors of intimate partner violence. Why? It's because hardship waivers and VAWA self-petitions and hardship waivers, one of the elements of those 2 petitions is that you have to be a survivor of domestic violence or have suffered domestic violence from an intimate partner. I'm sure most of you or many of you may have seen a power and control wheel, and this is the very traditional power and control wheel. What it says, and it kind of shows the dynamics of what the power and control is in a intimate partner violence situation, and what it and the definition of IPV. I'm going to keep saying IPV instead of intimate partner violence is a pattern of coercive and abusive behavior is used in any relationship to gain or maintain power and control over another. So the goal is a fixed imbalance of power. It's not a we're fighting, mutual fighting, where, yes, couples do have issues and couples have fights and marital issues come up and people fight. But when you're talking about intimate partner violence, there is the element that needs to be there, or that is always there, is a imbalance of power. One person controls the situation and makes it so that the other person is somewhat subservient to that person by using some kind of mechanism of either violence, physical violence, and or emotional control. Social isolation happens. Economic abuse happens a lot. And we'll talk about a lot of that later on as well. But this is big picture, what is intimate partner violence? And again, it's not just one incident, but a pattern. Okay. And many of our clients, because they are survivors of IPV or victims of IPV, they have experienced a lot of or set of circumstances that is experienced by an individual as physically or emotionally harmful or threatening, and that has lasting adverse effects on the individual's functioning and physical, emotional, or spiritual well-being. So trauma, we all hear about trauma, PTSD. A lot of war veterans have PTSD, and your clients will have trauma because of what they have endured. Sometimes, and trauma has a powerful impact on our clients. And the way it manifests itself, client may recall, their recall may be affected, gaps in memory. There's many times when we are doing an intake with the client and she can't get us, where we have to be very slow with that intake because she can't remember things. Us as lawyers, I think we always want to say, okay, give me the facts. What happened next? What happened next? What happened next? Sometimes that doesn't happen for our clients. Our clients can't recall that. It's very traumatic. They've sometimes buried those memories down, or it brings up something else. Maybe it wasn't that incident with their husband, but it brings up something from their childhood as they're trying to remember things. So again, trauma, it does affect it has a very big impact on your clients. And we're going to talk about working with trauma survivors next. And how do you do that? You want to be patient and judgmental. Reframe your questions. If your client is not able to answer a question or doesn't understand what you're saying, don't keep repeating the same question. Try to see if you can say it in a different way that would help her understand what you are trying to get at. And acknowledge and validate emotions, including your own emotions. If you are getting emotional, if you think you need to take a break, take a break. Schedule shorter appointments, especially now with the pandemic and everybody staying home. I know that staying home is stressful, and clients may have children at home. Everybody's in the house. Sometimes they are still living with their abusers. So again, take those things into consideration when you're working with your client. And we're going to talk about how to schedule those interviews, schedule those calls in a little bit as well. And if you think that your client needs other supportive services, connect her with those. Talk to us about that. We can definitely get you in touch with, or help you get in touch with, social workers and or counselors for your client through either her Justice's social work program and or the Family Justice Centers in New York City or other organizations. So again, if you think your client does need some other supportive resources and services, let us know. Big thing, everybody's talking about self-care these days. This is really important as you do this work, and it's one thing to remotely, and I think, like I keep saying, is everybody's under stress. I'm sure you all as individuals working from home, it's not the same thing, so you're under stress too. So take care of yourself. Make sure that you do take breaks, you do some self-care, and acknowledge where you are in this process as well. Okay. All right. Any questions on that? Those parts, trauma, DV 101? Okay, so working with your client, remote work. You're gonna, first and foremost, you wanna plan. You're gonna plan with your client. Set a remote communications plan. Discuss best times, methods of communications for both you and your client. Determine how regularly you will be in contact. Set boundaries and expectations. Your client may not want to do a Zoom call. She might have the capability, but she might not want to because she doesn't want you to see the state of her home. Maybe she lives with 5 other people. She's got kids running around. Who knows what's going on? So make sure you check in with her. It might be the most convenient for you to have a Zoom call, obviously, but it might not be the best thing for her. So just check in with her, see what's best. Things are opening up a little bit more in the city, but it's not totally open. She can't just go to a cafe or a coffee shop or a Starbucks or whatever to do that call with you, obviously. And that's also going to be, and even if she could, that would have some privacy issues too. So just think about those things. Think about the privacy and the attorney-client privilege, things like that may be broken if she has to speak in front of a large group of people. So make sure that you do try to keep those confidentiality parameters going when you set up this remote communications plan with her. Again, be patient and flexible. accommodate interruptions during conversations. I have 2 little kids. They keep running in and out all day long. I have told them today that if they come in, there's going to be some grave consequences. And I don't even no idea what those grave consequences are, but I just threatened them with that. And hopefully they won't be coming in and out. But your clients will have that. They may have that issue going on. So just remember to be patient, accommodate, and talk to them about what is the best plan. And again, also you might have needs with your technology or with your time constraints. Put that out front as well. Say, look, I have XYZ things going on as well as yours. We will be untouched, on these days. If you have a plan, it's better. It's always better for your client to be aware of what the next steps will be for her. And we can't emphasize this enough. Self-care, self-care, self-care. Even us at Her Justice who've been doing this work for a very long time, I mean, just out of sorts with a lot of things. So make sure that you do prioritize self-care. If you need to take a walk, take a walk. If you need to just veg out in front of the TV, do that. Binge watch something, who knows? Reach out to peers and supervisors. Again, your Her Justice mentors are there for you to help you through filing this filing process and throughout this process with your clients. So if anything, you can reach out to your Her Justice mentor. Just say, hey, look, you know what? I'm having a really hard time either connecting with her and or with myself. What do you suggest? And we have more tips for remote work. We have more tips for working within the COVID-19 pandemic parameters with USCIS. USCIS has put out guidelines for deadlines, etc. So please look at those very carefully in your manuals. And if you have any questions, please reach out to your Her Justice mentor. Okay. And here is this is just illustrating the attorney-client relationship here and the dynamics. So your client represents resilience and strength. Just to get to where she is a victory. That she called us, Her Justice, and reached out for help is a victory. And that she's found you to represent her, again, a victory. So that is your client, has resilience and strength. She has knowledge of what you need. Okay, I mean, what they need and what decisions are right for them. She has knowledge of her own situation. So, and we're going to talk a little bit more about this when we're doing the interviewing process, how to interview your client. But remember, your best source of information is going to be your client and what she can tell you. Okay, she may be in a highly stressful and urgent life issue, have highly stressful and urgent life issues beyond her case. So be mindful of that. She may be trying to get unemployment. Maybe she was eligible for unemployment and she's trying to get that, and it's not coming through. She might be, there has been a rent freeze for a while, but that's not going to be forever. So she might be worried about how she's going to pay rent for the next month when that rent freeze or whenever that rent freeze goes away. So things like that. Other things may be in her life. So just be aware of that. And she really likely has little knowledge of the legal process or court system. And who are you? You, attorneys, are dedicated. You have knowledge and experience with the legal system. You have the ability to help organize her case and convey it effectively. And you may be new to this area of law and to direct representation, but you also have us, Her Justice, as a resource to always fall back on. So again, look at this attorney-client relationship. It's a symbiotic relationship. You can help each other here. She has her application. You have the skills to be able to do that for her, to apply for her and get her on her way to getting legal status in the United States. Any questions so far? Okay, no questions. We are moving on. Working with Her Justice clients, helpful resources. Again, there's an FAQ in your manual, working with pro bono clients. There's also, again, like I said, working with your client through Her Justice during COVID-19. And then we also have a list of free services for clients during this crisis. And obviously we are here, her justice mentor is here, and we have a social work manager on staff that can also be a resource if necessary. Okay, so if no other questions on our overview, how to work with clients in this crisis, we're going to move right into the immigration law pieces, and this is the meat of what we are here for today. So without further ado, I'm going to first talk about the current status of U.S. immigration. We hear about it, well, before COVID-19 and the pandemic hit, it was all these attacks on immigrants. They're still happening. It's just not in the news as much. President Trump just a couple of days ago has he's trying to pass a bill or pass something that's going to gut the asylum system, gut the U.S. asylum system, so that, you know, asylum seekers really have very, very limited rights of seeking asylum. And so things like this are still going on, but we just don't hear about it as much. But what is the current state? The current state is there is a focus on enforcement and removal. This started off with the executive orders, the first two executive orders that President Trump signed in right after he was sworn in, which way back in January 2017. So shortly after he was sworn in, I think it was February, he started putting these executive orders in place. All about mostly focused on enforcement and removal and limiting immigration process. Like I said, he just is planning to do something, hopefully not, but he is planning, he said he's planning on doing something to address the asylum system so that it's much more restrictive. So it is continues on after 3.5, almost 4 years from his when he was elected. So that is the current state of U.S. immigration. So what does it mean? Enforcement priorities. Any criminal convictions, charges, or or anything like this, engaged in fraud or willful misrepresentation, this is where they're trying to enforce. Or the other thing they're doing is they're enforcing for anybody who is undocumented. In the past, if you were a visa overstay, you came in on a valid legal visa like a visitor's visa, and you just visa overstay. Visa overstays were not a priority for removal. Now, anybody and everybody who does not have proper documentation or proper status is a priority for removal under this administration. So that is the current state of U.S. immigration. You will hear it from your clients. They are scared. There's a lot of rumors going on. What's going on? Can I do this? Can I do that? It sounds like I can't bring my, I can't do this because he said that, you know, even if I'm a spouse of a U.S. citizen, I'm not allowed to come in, things like this. So there's a lot of rumors, a lot of fear. And that was the goal, is to, it's confusion and fear is what I think is the goal of this administration, and they're succeeding. So you are here to debunk some of those myths and help your client through this process. The administrative structure of immigration. Until 2003, it was all one agency, INS, Immigration Naturalization Service. It was this big behemoth of a department in the federal government. And they, after 2003 and after 9/11, 2001, they changed it up, and it's now under the Department of Homeland Security, and Department of Homeland Security is actually under the Department of Justice. So it's DOJ, Department of Homeland Security, and then Customs, and under that is you have these three separate parts, which is Customs and Border Protection. Customs and Border Protection means people, they're the ones that are at the border checking visas, checking that you have proper documentation. So the ones that are going after people at the border if individuals try to attempt to come in without inspection. We call that EWI, entry without inspection. So Customs and Border Patrol, their jurisdiction is 100 miles within the border. So it's at the borders and 100 miles up around the northern, southern borders of the United States, okay? That's why we tell our clients, hey, if you're gonna travel south, north, don't go too close to the borders, because CBP can come on to trains and buses or cars and search and ask for your documents, okay? And Citizenship and Immigration Services, CIS. So USCIS is who you will be dealing with. They are the administrative arm for the Department of Homeland Security and Immigration. So They are the ones that you're going to be filing all of your papers to. They're going to be the ones adjudicating your documents, or your client's documents, I mean, and they're going to be the ones that are giving you that decision. So CIS, they are an administrative arm. They are not supposed to be enforcement, but slowly they are turning into an enforcement piece. Like I said in my previous slide, the current state of immigration is enforcement and removal. And so CIS isn't supposed to be that. They're supposed to be adjudicating, fairly adjudicating on the documents that you send in is admissible documents or admissible folks, and they are becoming more of an enforcement piece. And we in the immigration advocacy, I mean, like in the community, have been advocating that they can't do that, they shouldn't do that. That wasn't the purpose of CIS, and so please refrain from becoming this enforcement arm, but they are slowly becoming that. Hopefully that practice will stop, but we never know, and we do keep advocating that they do stop those practices. Last is immigration and customs enforcement. ICE. You hear about ICE all the time. ICE in the courts, ICE on the streets. Anytime there's any kind of enforcement action within, after the 100 miles, right? ICE is the one that goes in. ICE, they're the ones that do the workplace raids for folks to do enforcement, to say, oh, you don't have papers, you're working illegally, what have you, and you're going to be deported or removed. Okay, so that's ICE. There was a huge victory recently with in New York State, where ICE is no longer allowed to be in the courts. Okay, there was a lawsuit, and the New York State Attorney General filed a lawsuit against the government for ICE to keep ICE out of the courts, and they were successful. So that decision came down, I think, 2 days ago, I believe it was, and so ICE is no longer allowed to be in the courts. But ICE is who everybody is afraid of, and when people say, oh, there's going to be ICE raids, that's who we're talking about. Okay. Any questions on the administrative structure of immigration? Okay. Categories of immigration. So we got non-immigrants. Non-immigrants are folks who are here for a particular span of time, brief sojourn through this country, right? So it could be students here to study, tourists who are here just for 2 months, 3 months, 6 months, at most 6 months. There you have your temporary workers who have a valid visa to be here as a temporary worker, H-1B being one of those things. And then there's others with limited stays, like crew members, etc. And then also in the bucket of non-immigrants are undocumented folks. Visa overstays would be in this category. People who have come in over the border without inspection, IWI, those people also are non-immigrants, right? And then you have your immigrants. Your immigrants are lawful permanent residents. We call them LPRs, or green card holders. So those folks with a green card or an immigrant visa, those are who we're calling immigrants, right? They are here to live and work and stay in the United States for a longer period than just 6 months. They actually live here. This is their home of residence. And they are free to travel in and out of this country. They can't leave. It is the U.S. will deem that you have abandoned your immigrant status if you leave for more than 6 months. And then in the last end of the spectrum is your citizen, right? The birthright, you were born in the United States, therefore you are a U.S. citizen. Or you're a naturalized U.S. citizen. A naturalization means like you were a lawful permanent resident, and then you lived here for 3 years or 5 years, depending on how you got your lawful permanent residency. And then you naturalized to become a U.S. citizen. You take an oath of citizenship, say that you will defend the Constitution, you are attached to the Constitution of the United States, et cetera, et cetera. You become a United States citizen, and now you have every right to vote. You have every right to be on a jury. You have the other civil rights that you may, in terms of voting and jury duty, things like this, that an immigrant does not. An LPR cannot vote, okay? That's the one thing an LPR cannot do. They can't sit on a jury, they cannot vote. Whereas a citizen, you can vote for your elected officials. And other ways you could get U.S. citizenship is acquisition and derivation. This is all about your parents having that status before you're at the age of 18, or they were when you were born, etc. So, and you may have been born elsewhere. Okay, and that's just a quick snapshot. Your clients, so how do people get the immigrant status? I'm going to go back one. Actually, your clients are either in this bucket of non-immigrants or in this bucket of immigrant. Obviously, they're not here, because if they were here, you wouldn't be, they wouldn't be needing your services. Okay, so they're either here or here in this spectrum, and depending if they're a VAWA self-petitioner, they're going to be here. If they're a battered spouse waiver, hardship waiver petitioner, they're going to be here. Okay. And how do people obtain lawful immigrant status? Family, employment, visa lottery, and humanitarian grounds. Okay, family petition. So it's, you have a family member who is a U.S. citizen or lawful permanent resident, and they petition for you. Your employer says, hey, you know what? I really need you to be the person that does this work for me, and I'm going to petition for you. So you can get it through employment. Visa lottery, there is something called the visa lottery, and it is really like the lottery. It's very difficult to get. And this is because this actually came about because they decided, hey, you know what? There are some countries that we actually want some people to come from. And we don't have a lot of people from those areas. So let's, if a person from that area wants to come, they could go into this lottery system, and if they're lucky, we will pick you to become a lawful permanent resident. It is really like winning the lottery. It is very hard. It's only about 6% of immigrants get it through the visa lottery. The bulk of it is going to be through the family, where this is the bucket where our clients fit into the humanitarian grounds. And humanitarian grounds are for folks who are seeking asylum, they're victims of crime, victims of domestic violence, victims of trafficking, special immigrant juvenile status, DACA. Those are the humanitarian grounds that we're looking at. And so obtaining immigrant status, it's always a two-step process, because you need one person, you need a petitioner to petition for you, and then you adjust status to get your green card. So you're adjusting from a non-immigrant to an immigrant. In the family context, it's a petition for an alien relative made by a family member. And the second step is the adjustment of status. Okay. And in this process, for the VAWA self-petition that we will be doing, the self-petition, you do no longer need an alien relative to petition for you. You can self-petition as long as you meet those requirements. We're going to talk about those requirements in a little bit. And then the second part, the adjustment of status, is the same. Okay. So who qualifies for VAWA relief? Spouses of abusive U.S. citizens or lawful permanent residents, non-abused spouses of U.S. citizens or lawful permanent residents where child is abused, unmarried, a child of abusive U.S. citizen or lawful permanent resident, parent of abusive adult USC over 21. Okay, so, but this seems kind of complicated. We're going to focus on the first one, spouse of abusive USC or lawful permanent resident. Every once in a while, we do have children that come in through our hotlines or helplines, and children in USC, US immigration parlance, children is anybody who's under the age of 21 and unmarried. Okay, so we do have people who do fit that bucket of children or child, and of an abused child of a United States citizen or lawful permanent resident. So again, we do have those clients every once in a while. But for now, this is where you are looking: spouses of abusive USCs or lawful permanent resident. Okay. So what is the benefit of a VAWA petition? Is the self-petitioner is in control of the application process. Because, and this is really important, because going back to that power and control wheel, a lot of times the abusive partner will use immigration status as part of that power. Okay, so there's threats of deportation, threats to have United States citizen children taken away, and if you are able to petition highly diminished, right? They can't, the person doesn't have that power over you to say, oh, you know what, if I didn't do this for you, you wouldn't be able to do this, because the self-petitioner can do it herself. Okay, so that is one of the biggest benefits of the VAWA self-petition. There are safeguards of confidentiality. If a VAWA self-petitioner is separated from her husband and no longer living with him, USCIS cannot actually let them know, cannot give any information to the abusive spouse about this process. So the abusive spouse really does not know that your client has filed for this. And the last and most important thing is it provides for work authorization, and which gives them economic independence. So again, they're not beholden to the whims and the power of their abusive spouse. They could do this on their own, and at the end of the day, they can get their legal permanent residency, and in the meantime, they can also get an employment authorization, which is equal to economic independence. Any questions so far? Okay, moving on. We're going to talk about what are the...
There is one question in the Q&A.
Okay. Sure.
The question is from Nilafar. What percentage of immigrants come in on humanitarian grounds each year?
Oh, good question. You know what? We have that in the slide, and I took it out because it just the percentages keep moving. I believe, don't quote me on this. I can get back to you on that, actually. I'm so sorry. But we did have that. It's in the, I think it's in the, somewhere in the 20s, something like that. Somewhere like that. I think like family-based is 65%, and then everything else falls after that. But I think it's like 15 to 20% is humanitarian grounds. Don't quote me. We could get back to you on that one, though. Okay, we did have a slide, and that slide had all the percentages, and I just took it out because, you know, but who knew? But I will get that back to you. Sorry about that. Okay. Okay, so what are the elements of the VAWA self-petition? So it's immigration status of the abusive spouse. The person has to have the abusive spouse has to be a U.S. citizen or a lawful permanent resident. The marriage has to be a legal and valid marriage. We're going to unpack all of these in a minute, but I just want to give the elements up front, and we'll talk in detail about each and every one of these. Okay, there's got to be a good faith marriage, shared residence, qualifying abuse, which is battery or extreme cruelty, and good moral character. The qualifying abuse, it must have occurred in the U.S. and during the marriage. And we'll talk about some scenarios where it may not have occurred during the, but how that all ties in. Okay, so to make it more interesting, we're going to talk about, I'm just going to give you a case study, a hypothetical here. And so it's easier to follow along and kind of put it together with a story here. So Victoria and Sergey met when he was visiting family in Ukraine. Victoria came to the US on a tourist visa and decided to stay and moved in with Sergey. The relationship was good at first, but Sergey became controlling and started monitoring everything she did. When she started taking English classes, he insisted on taking her to and from the classes, asking her about her friends, and looking through her phone logs and text messages. He also insisted on either being in the room or talking to her family when she called them in Ukraine, including the English classes. Victoria could only leave the house if Sergey was with her because she didn't have a key to the house. He told her that he didn't have an extra key for her and could not make one because the landlord would not allow it. Therefore, during the day, when Sergey was at work, Victoria had to stay in the home. The couple eventually married in 2014. Sergey has promised to file her immigration papers for her, but has continued to put it off, saying that they don't have the money right now. Whenever the two argue, he brings her status up to say that she is illegal in this country, so she better watch out. Sometimes the arguments have gotten physical, and Sergey has pushed and shoved Victoria. Once, when Sergey slapped her across the face, she pushed him back and kicked him to make him leave her alone. Okay, so she's from Ukraine. They met, got married, and he hasn't filed anything for her so far. Okay, so first poll, or this is my fourth poll, but first poll about them is all of the following can be used to prove Sergey's immigration status except. Birth certificate, passport, family record, like a Bible, or driver's license. What cannot be used to do this? Okay, I think so. Nobody said birth certificate, which is good because yes, if the birth certificate is U.S. birth certificate, or you know, you could prove somebody where somebody was born. Passport. Passport is something that can be used, especially if it is a U.S. passport. So it can be used if it is a U.S. passport. This is a little bit of a trick question, right? Because it depends on where Sergey was born. If he was born in the Ukraine, obviously his birth certificate won't say he's a U.S. citizen there because he's not born here. But we're going to assume that he was born. Again, if he's a U.S. citizen, he has a U.S. passport, that can help. Family record or Bible actually can be something that we can use. And it's actually, it is, if it's something that, like, say that they couldn't register the birth for some reason, a lot of rural areas in the past and sometimes still, like, register somebody's birth in a Bible or in a family ledger or something before they can get to a hospital or they can get to the city hall or wherever they need to go to register a birth. So it just depends on that. And the family records, they have, USCIS has accepted that as a record of birth if you have that. Driver's license. The driver's license is where it is tricky. It's actually a driver's license that may not be, you might not get that, the citizenship. Right now, I know that a lot of states, it depends on the state, right? Because a lot of states have that enhanced ID. The enhanced ID will show it. The enhanced driver's license will show somebody's citizenship and or their status, you know, but the majority of driver's licenses do not show immigration status. Okay, so it depends on what kind of driver's license it is. Okay, so this basically is to illustrate to you, you have to look at every single piece that the client brings you, like, or the evidence that she may or may not have, and talk about them. Like, say, does he have a birth certificate? Do you have a copy of it? If he doesn't, then what else do you have? Do you have a copy of his passport? What else do you have? Nothing? You have nothing for him? Then there is actually a statute section that where USCIS is supposed to look his status up. You supply them with as much information as you have, his date of birth, maybe his when he naturalized, if he did naturalize, or he became a lawful permanent resident, his social security number, things like that. Whatever information you have for him, you put into a chart, you ask USCIS, hey, this is all the information we have for him. Please look him up in your system and verify his status. Okay, so there is that. If your client has absolutely nothing, okay, so and this was just to illustrate to you the different types of things your client might bring and how you're going to look at it, examine it, and talk to her about other things if she doesn't have primary evidence of his status. Okay. Okay. Any questions on that, proving his status? Okay, so like I said, birth certificate, passport, other immigration documents, and then you're going to request USCIS searches records. The most difficult people to find status for are those who are born in the United States and never, ever, ever applied for a passport. They never left New York City, don't have a driver's license, nothing. Okay, and the only piece of evidence might be his birth certificate, which she may not have access to, but she might, but be very creative in that. Maybe she has access to tax returns. She has his social security number that she, because they filed joint taxes before, something like that. So be creative when it is a situation where there's absolutely nothing, and you're going to have to, try to give something to USCIS to prove his citizenship. Okay? And then the next qualification was a legal valid marriage to a United States citizen. So marriage certificate, judgments of divorce, English translations of documents. So what we mean is you need that marriage certificate. It needs to be a valid legal marriage, meaning you need to have, it can't be just a religious marriage, okay? Unless sole religious marriage is a valid legal marriage in the jurisdiction where that took place. So if in their home country, they got married in their home country and it was a religious marriage, and a religious marriage is enough to make it a valid legal marriage, that's good. However, if they got married in New York, you need a marriage certificate. It cannot be just a religious marriage at church, mosque, wherever else they may have gotten there married, okay, religiously. So you need to have that marriage certificate in New York State. And when we say judgments of divorce, this is the valid legal marriage because your client cannot have been a bigamist, right? So if she was married to somebody prior, you need to have proof that she was actually divorced from first husband number one before she married husband number two, who is the abusive spouse here, okay? Now, there is something called a bigamy exception for VAWA self-petitioners. If it was not her bigamy, but his, he was married before, he never told her that he didn't divorce her, his first wife, and he says, yeah, you know, I'm separated from her, yes, we got a divorce, let's get married. She believed in him solely because he said that, but he wasn't divorced, that's okay. There's something called the bigamy exception in the VAWA self-petition process, okay? So when we say judgments of divorce, the judgment of divorce has to be your client's judgment of divorce from her prior husband or partner, not your, not the abusive spouses, okay? So again, valid legal marriage, if it is good and legal and valid in the jurisdiction where it took place, it is a valid legal marriage. A lot of our clients, I mean, one example I have is my client got married, her family and his family married in Mali, okay? And it was a community thing where families got together and they said, okay, say in a church or anything here. Then after that marriage, which was recognized in Mali, they then went back to the Mali embassy and got married again in the Mali embassy. Again, that's a valid legal marriage, okay? So there might be some situations where things happen and you're thinking, oh, is this right? If it was correct in the jurisdiction where it took place, it is right. The only thing that might not work is if it was like a proxy marriage and it is against public policy, okay? So in those kinds of situations, talk to your Her Justice mentor. I don't think any of the cases that we have placed with you guys this summer has that situation, but if you in the future run into something like that, just know that that might not be a valid marriage, okay? How do you, and then the next thing is prove and good faith marriage. What is good faith marriage? It means that it's intent to establish a life together for any reason other than purely to establish contractual relationship to attain an immigration benefit, okay? So it is what was their thinking at the time of marriage, okay? It's got to be, hey, I want to have a life with you. And it can be, I want to have life with you, and yeah, let's normalize my immigration status, okay? But the normalizing the immigration status can't be the sole reason. So I can't have paid X person to marry me so that I can get my immigration, my green card, is basically what they're saying. And this is because they're looking out for marriage fraud. So you have to show that there is a good faith marriage. The standard of proof here for all of this is a preponderance of the evidence using any credible relevant evidence. And this is in the VAWA statutes, this is in policy, this is a memoranda. So if you should try to get the best evidence, but you could get any credible relevant evidence, okay? So, so with that, let's talk about how you can prove that they try to establish a life together. How can Victoria show good faith marriage? Say that they have a child, a birth certificate of a child, affidavits from friends, self-affidavit, all of the above. All right. So all of you are very, very awake this morning and uh, and have answered properly and correctly. It's all of the above. Uh, a joint life and wanting to show good faith marriage, and then affidavits from friends can help. Obviously, if the friends say, we spent time together, we went here together, they came to our house and we did this, and I went to their house and we did this, and then a self affidavit, your client is going to talk about this, right? That's going to be the main piece of your application, is your client's self affidavit. So all of the above can be used. You can get more if you don't have primary evidence, like bank accounts and things like that. All of this is going to help as secondary evidence. Affidavits from friends and self-affidavit. Birth certificate is a primary evidence. Other primary evidence would be commingling of lives and finances. USCIS loves that word, commingling of lives and finances. So, or those words actually. So you're going to show in whichever way you can, right? Do they have a joint bank account? Do they have life insurance? Do they have car insurance? Those kinds of things that show that's primary evidence to show that there was commingling of lives and finances. I am going to read a code right now for those listening in later on, because this is being recorded. So the first code here is RT is in Tom J04. So it's RTJ04. Okay. Any questions on good faith marriage and how to prove it? Okay, we're moving right along then. And beyond good faith marriage, you have to show there was some shared residence. Yes, Mike?
Yes, there is a question. Again, from Neilafar. What if in the case that the marriage is forced and the self-petitioner agreed because of the benefit of immigration status?
So what do you, in terms of forced marriage or arranged marriage? I think most of the times when you can kind of flip that from forced marriage to arranged marriage, meaning that she was probably forced by her family. And so it would be what we would couch it as an arranged marriage. And actually arranged marriages are one of the easiest to prove as a good faith marriage, because in the not so distant past, it was harder to prove that an arranged marriage was a good faith marriage. But nowadays, USCIS is understanding more of cultural nuances and the way, some cultural nuances. So arranged marriages are actually pretty easy to prove as good faith marriage. And in the affidavit, that's what you're going to say. You're going to say, I married, my family decided that I needed to get married. They picked this guy for me. I didn't like him. However, because in my culture, I'm supposed to be dutiful and to listen to my elders or what have you, I did it. And, I figured I would try to make the best of it, et cetera, right? So as long as the sole reason for getting married was not immigration status, but it was an added benefit, okay, that's great, but so it's okay to, if it is a arranged and or forced marriage. Does that make sense? Okay, so then the next requirement is a shared residence. How do you prove shared residence? Again, and a lot of the shared residence may also fall into the bucket of good faith marriage as well. So you could say good faith marriage / shared joint residence in your index of exhibits. Okay, so what are you going to show for shared residence? And this is a qualification that they need. And it's crazy because USCIS is still focused on the traditional marriage where parties move in together, maintain the same address. So they still want this evidence to show that there was joint residency. There is no minimum period of joint residency though. So just remember that. They just want some evidence of cohabitation. So it could be they lived together for 1 week and the abuse started and she left because she was like, I'm not going to have this. Other times, I know petitioners or practitioners and petitioners have been successful in a 3-day joint residency where it was the 3-day honeymoon where they actually lived together in a hotel. And after that honeymoon, she decided, you know what, he was so abusive, like she left. Okay, so if it isn't like your traditional, yes, we moved in, yes, I have this and that. I mean, it was a very short period of joint residency. Be creative, talk about it. Try to, think of ways that you can make it known that it was joint residency. Maybe they maintain two different households, but every weekend they came together, and that has happened because people have separate families. Like he might have him and his kids, and she had her and her kids, but on the weekends they got together at either one of their houses, and that was the arrangement, that every weekend they would be living together. He kept his things at her house, she kept her things at his house, but during the week, because like kids' school schedules or what have you, they were separate, but they came together in the weekend. So you again, shared residence, you want to explain it if you don't have the joint bills, leases, things like that can show this, okay? And these are other ways to show it. The marriage certificate may have their residence as a joint residence, mail that was sent to either one of the parties at that same residence. Questions? Okay. And then we go to proving qualifying abuse. You need to have qualifying abuse. It could be battery of violence, right? Kicking, punching, slapping, and threatened acts of violence against victims or family members, threatening somebody, coming really close to them and saying, watch out for, or else, or like putting their fist in their face, in somebody's face, things like this. Sexual abuse, rape, molestation, forced prostitution. This happens a lot. Your clients may not want to talk about it. They might gloss over it. They might, and it might be difficult for you to talk about with them as well. We'll talk about affidavits and how to craft those affidavits, and we'll talk about how to, weave these stories into your client's affidavit, okay? And then the other one is extreme cruelty, right? If there was no battery, but there was extreme cruelty. A lot of clients say he never physically hit me. He never did anything, but there was social isolation. There was stalking. He watched me everywhere I went. He called me 100 times a day. He would get angry if I didn't answer the phone, and he actually called my boss on me, or he would be always waiting outside my work to make sure that I didn't go anywhere. Verbal abuse, denigration, threats, constant using just, social and economic status as well. So think about those things as extreme cruelty if there was no battery. And we could talk more about that here in this next poll. So which of the following does not constitute extreme cruelty or battery? Extramarital affairs, controlling phone and social media, threatening deportation, verbal put downs. Okay, we're going to end the poll, and many of you answered extramarital affairs, and that is right. We're going to talk about the other ones first, and then I'll get back to the extramarital affairs. Controlling phone and social media is a form of control. So basically, you're going to say, he looked at my phone. So when it seems like it doesn't quite fit into the physical battery or extreme cruelty, you're going to say why it does, right? Why does controlling phone and social media fit here? It fits here because he looked at her phone. He always watched who she was talking to. He deleted all her mail, obscene pictures of her, whatever it is that he's doing. Threatening deportation is huge. And it is a form of control, obviously, to say, if you don't do X, I won't do Y. I won't apply for your immigration status. If you don't, have sex with me every day, you're not worth it, and I'm not gonna have, I'm not gonna apply for your green card. Verbal put downs: you're ugly, you're a horrible mother, I should never have married you. Things like this. Verbal put downs can be a form of extreme cruelty. So again, when it seems like, is it not? You have to explain why it is. What effect did it have on your client? How did she feel about it, right? And then we're going back to the extramarital affairs. Extramarital affairs are not, does not constitute extreme cruelty or battery unless he says it like this. He says, I'm having these affairs because you are worthless. You don't give me what I need, so I'm going to go out and find it somewhere else. Okay. Or I'm going to go out and get a disease so I can give it to you. Okay. That would constitute extreme cruelty or battery here. Okay. So it depends on the circumstances of the extramarital affair. Say that he just was shacking up with his ex-girlfriend after he married your client. That's not going to be one of these things where it's extreme cruelty or battery unless he uses that and weaponizes that act to make her feel less than, or to keep telling her she's not good enough or not good as this other person. Okay, so a lot of your clients, if there is extra, and we put this in here, I put this in here because a lot of your clients will focus on that extramarital affair because they feel so hurt and slighted by it. Okay, how dare he go out and do this, la la la, right? But yes, that was hurtful, but was it an intentional hurt? Was it intentionally to make her feel X? Not that she felt that, but was it intentional? Was it a way that he was using that as a means of power and control over her? Okay, so think of it that way. Your clients will want to throw in everything in the kitchen sink, but you gotta get back to the basics, get back to the elements, the essential elements, okay? Because you don't want to put too much in, you don't want to put too little in, but again, it's if you start throwing things in, it kind of opens the door for USCIS to ask, oh, what about this and what about that, when they're not necessary to adjudicate her application, okay? Questions? Okay, so, and then you got your good moral character is the last qualification here. And how do we prove good moral character? You get lived 6 months or more in the last 3 years. So if your client just arrived from X country and she hasn't been here for more than in the last 3 years, like, so she arrived last year, okay? You would need a good conduct certificate from home country, okay? Or she moved here from Connecticut, you would need a good conduct certificate from Connecticut. As long as she's been in New York City for the last 3 years, you just need it from New York City, okay? But anywhere else she has lived for more than 6 months or more in the last 3 years, you will need it from that jurisdiction as well. Something to note, NYPD certificates expire in 60 days. So we always advise that clients go get that towards right about the time that you are ready to file it. Currently, NYPD office that does the records check and does the fingerprint checks, they are closed because of COVID-19. They say that they will reopen soon. We have been working with the New York Mayor's office to end gender-based violence to kind of see if NYPD will open on appointment based only for some of our clients that need this now. So if you get your file ready and it's all ready to go. I don't know if, I know a lot of you have shortened programs and it's going to be, you have 6 weeks, 4 weeks, depending, or 5 weeks, depending on what your summer program is. So if you are efficient enough and then get it ready and this is the last thing you need to do and they're still not open, we have been able to kind of tell USCIS these are the reasons why we can't get it. Our client has done her due diligence to try to get these things. We cannot do it for you right now. However, when it is things are open, we will get this to you. And USCIS has accepted that as okay, fine, and given the prima facie determination, which we'll talk about in a minute. Okay. So good moral character basically means you don't have bad moral character. If you want to look at INA section, Immigration Nationality Act, okay, that's this, those are statute sections that we look at, Immigration Nationality Act, and it's section 101F has all those things about good moral character, okay, or what constitutes bad moral character. Okay. And this is the standard of proof. Again, I'm going back to this, is any credible evidence, and it's by a preponderance of the evidence. Again, and here's such a section that says where that can be found. And we're going back to the affidavit. So now you interview your client, she meets all those qualifications. Okay, we at Her Justice have done a cursory interview of the client and have found that she is eligible. Okay, some of those, and if you look at your case opening reports, which you will all get with your file, is your case opening report will give you, we might put in issues, next steps. It might be, she does not have a lot of this. Work with your client to get X. Okay, work with your client to make sure that she can fulfill X. Okay, whereas because we see the elements are there, she might need a little bit more bolstering in certain parts of those of that application. So where are you going to do that? First and foremost, it's going to be in this affidavit, your self-petitioner's affidavit. This is where she's going to tell her story and why she meets every single one of those criteria to actually be able to apply for her VAWA self-petition. The affidavit is organized chronologically. It's how she met him, so it's going to be chronologically and hitting those elements, right? So met him, good faith marriage, joint residency, all that stuff, okay? And then again, I keep talking about this, is if you don't have something, say why it's not there. She doesn't have any evidence of commingling of lives and finances. Why? Because he controlled the finances. He kept everything from her. He told her, you don't have a social security number, therefore we can't open a bank account. Or he said, you know what? No, I have the power here and you can ask me for money. I will give you money. He gave her an allowance of $20 and had her account for it, right? So that can be abuse, and why she doesn't have the other evidence. You could use that in both places, right? One of the ways he controlled me was financially. He did X, Y, Z. Therefore, I don't have this, okay? So if you don't have something, or if your client doesn't have something, explain why she doesn't have it. Most of it is going to be because there was some kind of power control over that piece of information or that kind of evidence so that she can't supply it. Okay? You will be writing this for her. Okay, it's going to be authored by you, but in the client's voice. So don't cross-reference. You don't have to cross-reference evidence. That comes later on. Don't say, please see Exhibit A, blah, 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 Exhibit B, blah, blah, blah. Okay, don't do that. You don't have to cross-reference anything because it's coming from your client's voice. And USCIS likes it better when it's not so legally and it's actually like reads as if somebody, a layperson is writing it. So make sure, and one of the ways, like especially now during this, the pandemic, since you will be working remotely with your clients, one of the ways to cut down on maybe a 3-hour-long phone conversation where you're interviewing her is to actually ask her to start outlining, right? Give her, like after your first interview with her or first meeting with her over the phone, you can say, here, these are the elements that we're looking for. Can you like maybe give us, like start writing out X or Z, or Y, whatever it is. And so as long as your client starts writing it out, you can clean it up, ask her for more details on certain parts. It will make your life easier. And it will probably make her life. Okay. One thing is, it needs to be consistent. If you have affidavits from supporting affiants, make sure that things are consistent. If you are saying something in her affidavit, like, I called the police and they came and took a report, make sure that you have that police report. If you don't have that police report, say, I called the police, they came and took a report. I don't have that police report because he took it, and or I moved and I lost it in the move, and or the police never gave me a copy of that report, okay? Because if you talk about something, don't include it or don't explain it, there's a big high likelihood that later on USCIS may send you something called a request for further evidence. So remember that. And also the other thing that you do want to think about in your affidavits is throw in all the nitty-gritty details, because all of the elements are going to be the same for all the clients, right? So everybody's going to have a good faith marriage. Everybody's going to have joint residency, but you want it to be not generic. It can't just be like he and I met and we moved in together. You need some details to show that it's this particular client, your particular client, and these things happen to her. It can't just be, oh yeah, you could be talking about the neighbor down the street that this happened to, okay? So just make sure that you do fill in details from her life that pertain to her story, and that will get her the benefit. Any questions? Okay. So if you get your lawful permanent, your VAWA self-petition, which is on the form I-360 approved, what does it do, Mike? Yes.
Sorry. There is a question from Maria. What happens if they deny the visa? She has to leave the country immediately?
No, she does not have to leave immediately. If they deny it, there are other remedies. We'll talk about that later on, if like in terms of like what kinds of things you may get from USCIS, okay, after filing. And of course, your clients are going to be wanting to know that, so we'll talk about that in a minute, okay? And I'll get to that. So benefits of an approved I-360 is you're eligible to adjust to lawful permanent residency, and if you are married to a U.S. citizen, it's an immediate eligibility. And if you're married to a lawful permanent resident, if your client's married to a lawful permanent resident, she may have to wait for a visa availability, okay? If the I-360 is approved, your client will get deferred action status. Deferred action status means that the U.S. government knows she is here, but they are not going to take any, she's on deferred action. They're not going to take any steps to try to remove her, okay? And then she's eligible to get the employment authorization. And all of these benefits extend to derivatives and children, okay? So speaking on that, we're going to talk about children, divorce, death, and remarriage. So any other questions on the 360 piece, the VAWA self-petition piece by itself? Okay. So we have derivative beneficiaries. Derivative beneficiaries, like I said, children in immigration parlance is unmarried and under 21 at the time of filing. Okay, so if your client has children who are under the age of 21 at the time of filing, they can be included as her beneficiaries. There can be here in the United States or abroad in home country. You list them on the I-360 self-petition, and they are her derivative beneficiaries. There is something called an age out. If the children turn 21, they age out of, as long as they were included in her petition before they turn 21, they will always be her beneficiary, her derivative beneficiaries, her derivatives. Okay, no matter if USCIS takes so long to adjudicate the application that the children turn over 21 at the time, it's okay as long as they were under the age of 21 when she filed it. Okay, so they will always be her children. And then. Okay, and then next question is, so some of your clients' children are here, and you might be doing a concurrent application for her and her children. We're talking about, I'll talk to you guys about concurrent applications in a little bit. And so you have to think about ethical considerations because there's going to be dual representation here. Your duties are owed to both principal and derivative children. There's duties of loyalty and confidentiality. Conflicts of interest may arise. Usually not an issue for young children, but conflicts may arise with older children and parents, and we have seen this multiple times. Teenager wants to rebel, starts whatever, being not listening to mom. Mom may lash out. There might be some physical violence on either side. Police are called, something happens, ACS is involved, what have you. Okay, so things happen in people's lives. So just make sure that if you have this situation where there is a dual representation because there are derivative children that are here in the United States, okay, write that into, you're going to write that into your engagement letter. You will have an engagement letter for both mom and the children, and it's always good to put it up front that there is, representation of mom and child, and talk to your firm's ethics department about how to address that in that engagement letter or retainer. Again, if you have the informed consent, it is a way to resolve potential conflicts and, clarify responsibilities in that retainer. And usually, like if you say informed consent, it's like, hey, that we're representing her. If in the case of a conflict of interest, we will continue to represent X mom, or or we won't represent either one of you, and we will need to refer you to other agencies, what have you. Okay. There's going to be, our clients' lives are not static. Obviously, during certain things, during the process here, things may happen because USCIS is taking quite a long time to actually adjudicate some of these things. So the impact of divorce or remarriage of self-petitioner, right? So impact of divorce. If you're self-petitioning, if you have your self-petition pending, there is no impact for a divorce. Your client might say, looking at it, they haven't gotten back to you with a decision, and your client calls you up and says, hey, I want a divorce. So okay, she can get a divorce. There's no impact on that pending application. If she was divorced prior to applying, okay, say that you got the application and she tells you, oh yeah, by the way, I forgot to tell you, but my divorce was pending and now it's finalized, I am divorced. You have, or she has, 2 years from the final judgment of divorce to file the self-petition. Okay, so say that her final judgment of divorce is January 1, 2020. She's got until January 1, 2022 to file the self-petition application. Okay, the divorce grounds are irrelevant here. A lot of clients will say, oh my goodness, what's going to happen? Do I have to get divorced on the grounds of cruelty, that he was cruel to me? No. It does not have to be that. It could be irretrievable irreconcilable differences, irretrievable breakdown in New York. That's what it is in New York. However, it may pose a problem if the he filed for divorce and he claims that she was abusive to him. In that case, you will have to explain that. Okay. And then what happens if your self-petitioner calls you up and says, hey, oh my God, I want to get remarried, and it's not yet adjudicated. A lot of clients will say, you know what, I'm divorced from him and this is going, but I met the love of my life. He wants to get married. I want to get married now. The self-petition is still pending. You haven't gotten a decision. If your client gets married while the self-petition is pending, the self-petition is invalidated. It is no longer valid. She will get denied, okay? If the self-petition is approved, there is no impact, okay? She can get married after the self-petition is approved, even before she gets her green card. That's okay. Maybe the green card application is pending, but as long as her self-petition, the 360 is approved, there is no impact of her getting remarried. And there's no revocation there, but they will revoke if she gets married while it is pending. And a lot of clients, this has happened. They get married. They don't tell us. We get the approval notice. Then they tell us, oh, but I married him 6 months ago before the approval came. And then later on, it's found out, USCIS finds out, because you're going to have to, when you're applying for something else, you have to say that, are you currently married? You can't lie about that. And then they're going to be, oh, they're going to revoke it, and you might get a notice of intent to revoke. Okay. So just, if your client ever calls you up, or just tell her, listen, you cannot get married. If you want to do any of these things, you got to let us know, so we can advise you properly. Okay. A loss of abusers' immigration status. For example, they lose their lawful permanent residency and they are removed or deported. It is okay up to 2 years if the loss is related to domestic violence. If that abusive spouse lost his immigration status because he was like controlled substance trafficking and controlled substances, drug trafficking, and he was removed for that, she won't be able to take advantage of the VAWA self-petitions process, okay? But if he was removed because it was like multiple counts of domestic violence and he kept on violating it, and it is a removable crime, okay? Deportable crime is, so he may be deported for that, and if that's the case, then she can, up to 2 years from that removal date, she can apply. Death of a U.S. citizen abuser. If the U.S. citizen spouse dies, it's okay to apply within 2 years, okay? Again, he dies January 1, 2020. She's got until January 1, 2022 to apply for her VAWA self-petition. Now, if the abuser was a lawful permanent resident, unfortunately, she's ineligible to apply for a VAWA self-petition, okay? Any questions here? These situations rarely come up, but they do. So this is there just so you guys are aware that certain things may happen after or before you, while you're working on it, or after you file it. The client's lives keep going. And so this is why it's really important to keep in touch with your client. Even if USCIS is taking a year and a half to actually adjudicate these things, you want to check in with your client every 4 to 6 months, okay, just to make sure things haven't changed drastically. Okay, so, and I keep talking about these things: adjustment of status, lawful permanent residency. So these are things that can, other applications that may be filed concurrently with your client's I-360. Again, like I said, it's a 2-step process. First process is going to be, the first step is the I-360 self-petition process. Has to happen. And then it's the adjustment of status, where they are adjusting status to become a lawful permanent resident. Sometimes that process can be a 1-step process. Other times it's a 2-step process, okay? When is it a 1-step process, and when can you actually apply for your adjustment of status? Okay, it is filed on Form I-485, and the eligibility is you either have an approved I-360 self-petition, and or you can concurrently file if the spouse is a U.S. citizen or an immigrant visa is available. Immigrant visa means that the availability of an immigrant visa, what I mean by that is the Department of State controls how many people from different countries come into the United States as an immigrant every year, okay? So they look at overall worldwide numbers and think, okay, in this eligibility category, we have only it's called a visa bulletin, and you're going to look at the visa bulletin, and if you Google visa bulletin, it'll show up, and it's just a chart basically of each kind of immigration category and when it is when there are visas available for folks to apply. Right now, spouse of a lawful permanent resident, it is current, meaning that you can apply together, okay? But talk to her justice mentor if you want to discuss your client's eligibility if her spouse is a lawful permanent resident, okay? So again, you either have to have an approved, I-360 or be concurrently filing one, filing with the I-360. And then the person has to be present in the United States and not inadmissible. Present in the United States, meaning that if you're obviously, none of your clients are abroad. However, sometimes we do have clients who are abroad who have a 360 that is approved. They can't file a 485. They have to do a visa processing, immigrant visa processing abroad at the consulate. So your clients are all present. So, you know, you can kind of ignore that second prong because they are here, but they also have to be not inadmissible. What does that mean? That means that the U.S. government wants you here. They want to admit you. They want you to be a lawful permanent resident. Common grounds of inadmissibility are all under INA Section 212A. Please look at INA Section 212A because it is important. It's good to know what kinds of people that U.S. government doesn't want in the United States. We do have in our manual, we do have VAWA red flags checklist. So it's kind of more in the lay parlance of like asking your client, did you do this? Did you do that? This is all captured in the I-485 form as well. And whether or not, depending on what she answers in that I-485 form questions, it triggers some of these inadmissibilities. So if she has a yes answer, talk to her justice client about it. I mean, her justice mentor about it, so that we can walk you through. Does it rise to the level of an inadmissibility? If so, what are you going to do next? Okay. So common grounds, health-related grounds, criminal-related due to convictions or admissions, fraud or misrepresentation. A lot of times our clients had that fraud or misrepresentation because they came into the United States using somebody else's passport, somebody else's visa. Or they came in and out of the United States. It triggers inadmissibility for unlawful presence. Again, these are all very nuanced, depends on the client's situation, the facts. So if your client says yes to any of those questions and you are concurrently filing a 485, please talk to her justice mentor about it. One of the things about the health-related grounds is that you do need, at the end, one of the necessary documents is a medical exam from a civil surgeon. So that usually gets, a lot of times our clients, one of the health-related grounds that makes you inadmissible is if you are a harm to yourself or others. So suicidal ideation, suicidal thoughts, suicidal attempts may trigger this ground of inadmissibility. So when you are crafting that affidavit, talk to your client. If she says, I wanted to kill myself, think about how you really want to say that. Do you really want, did she go through the motions? Did she actually do it? Was she committed? If that is the case, yes, you have to put it in, and you may need to get a psych eval and a civil surgeon's like sign off that she is not going to be a harm to herself or others. However, if she says, I was so distraught, I sometimes thought I wanted to end it, but talk about that with her, okay? Was it really suicidal ideation? Was she just so upset that it was like a passing thing? You know, there are certain times when like I like a lot of us were like, oh my God, I just want this to end, right? So is it that, or is it like, I really want to kill myself? And so I went and drank a glass of Clorox, okay? Talk to her about that. We've, you know, because you don't want to invite an RFE from USCIS when it's not necessary. And then when you're gonna, if your client does say, hey, yes, something, I'm going to say yes to one of these questions, and it does trigger an inadmissibility, or it seems to, you have, you know, you're going to go through this, the general arguments against inadmissibility, i.e. the ground does not apply. It doesn't apply because there's an exception to it, okay? Or it doesn't apply to my client because, you know, she came in on a valid visa, whatever it is. And then even if the ground applies, you can, she qualifies for a waiver of inadmissibility on Form I-601, okay? This is, the waiver is a discretionary determination. So you need to say why she deserves this waiver, okay? I.e. it was fraud or misrepresentation. Yes, I came in with using somebody else's passport and somebody else's visa because I was desperate to leave my country, because I was being pursued by gang members and I really needed to get out of the country, right? And I came here. I know it was wrong. However, this is the only reason I could do it. This is the only way I could do it. And, you know, there is a VAWA specific waiver. There's going to be a hardship to me, to the client herself, if she were to be removed from the U.S. The hardship can be to her or her U.S. citizen children if she has any, okay? So, and talk to her justice mentor if you have a 601 waiver that is necessary. So you need to do this, okay? There are certain things that are not possible other remedy if exception or waiver does not apply. For example, false claim to U.S. citizenship, you cannot get a waiver. It is not waivable under the 245A 245A adjustment. Okay, you have to do it. It is waivable on. So if your client says, "Oh, you know, I use somebody else's U.S. passport," that's going to be an issue. You won't be able to file the VAWA self-petition, but there may be another remedy, another immigration remedy for her, probably in the form of a U visa. Okay, so if that happens, your client comes up with this, let her justice mentor know, and we can talk about that. Okay. Your clients will ask you, hey, if I file, after I file this, can I go home? Okay. Because many of your clients may not have been home to their home country in many, many years, 10 years, 15 years, 20 years. You know, life happens in their home country. They haven't been able to see their mom or dad or siblings or anybody, and they want to go. So if they say, okay, can I go? Well, their departure may trigger unlawful presence. If they have been in the United States for over a year without proper documentation, they leave. They trigger what is called a 10-year bar. If they have been in the United States for over 6 months, but less than a year, and they leave, they trigger what is called a 3-year bar. So if they want to leave after they file this application, you can also concurrently file Form I-131. It is advanced parole. Basically, you're saying, my client, there's humanitarian reasons why she needs to travel. Please give her advanced parole, which is advanced permission to leave and come back in the status she was in when she left, okay? And it will not trigger any unlawful presence requires, okay? So again, if your client says she wants to leave, please talk to her justice mentor about the possibility of filing a Form I-131 concurrently, okay? Or even after the fact. I-131s can only be filed for if you have an I-485 pending or concurrently filed, okay? The other application that can be concurrently filed is application for employment authorization. Again, this allows your client a right to work lawfully in the United States. It's a huge deal. It gives her economic independence. It'll give her social security number. She can open a bank account. It will open doors to state and city IDs, and then it is another form of ID. To be eligible for employment authorization, you need to have a pending adjustment of status application, the pending I-485, or you have to have an approved I-360, which gives you a deferred action status, okay? And the thing with the employment authorization document, it is that it must be renewed every year until the adjustment of status is approved, okay? So, all right. Any questions so far on the concurrent filings? I know this is a lot of information and I threw a bunch of stuff at you. One thing to note is that when you are filing only the I-360 or you think you're the 485 later, there is a question on the I-360 where they ask you, do you want a employment authorization, okay? And you just check off yes, and it will be automatically sent. We recommend that you do this unless you know for sure that there is going to be a concurrent filing with the 485 and 765 at the time that you file, because sometimes we think, oh yeah, it's going to follow shortly, and sometimes things happen so that you can't immediately file that 485 or the 765. So just make sure that it's not going to be a concurrent filing, that you do check off that 360 on the 360 form, the yes to, do you want an employment authorization? Okay. Filing the applications. Okay, any questions so far? Concurrent filings, application of the other applications. So we're going to talk about the nuts and bolts of actually what you're going to file. So you have now talked to your client. You've written the affidavit. You've had back and forth with her justice mentor in terms of, and we're going to talk a little bit about that, sending it to us and everything. But and now you've got everything together. Okay, what are you going to file? You're going to have a cover letter. You're going to have the Form G28. The G28 is your notice of appearance printed on light blue paper, if possible. If not, during this pandemic, it's okay. Just print it on white paper. A Form I-360. You're going to have your index of exhibits and your exhibits. Okay. Remember, you as the attorney control the record. So if things don't need to be in there, don't put them in there. If you have an ACS report about some parts of abuse, you don't have to put the 80-page ACS report if it has damaging information about your client. Look at every single piece of information or evidence that you are going to include. If it's going to be damaging or if it is not necessary, you don't want to include it, okay? Because you do not want to invite USCIS to RFEU, ask for further evidence, or deny you because they found some piece that's, that was damaging to your client that you cannot then explain. So just look at the record again and again and again and make sure that you do you include things that are necessary, but don't include things that are not necessary. Okay, documents should be signed in blue ink. The signature issue right now because of COVID is different. So look at the advisory that is in your manual regarding signatures. They are accepting photocopy signatures, but they are not accepting electronic signatures. So there's a difference, right? Your client can sign it and maybe she's able to upload it somehow and send it to you instead of the snail mail. And you can actually USCIS is requesting that you keep the wet signature page somewhere. so that if in fact later on they ask for it, that you can send it into them, okay, after this pandemic is over. So make sure that signatures, you look at that advisory that we have in your manual regarding signatures and how to file everything at this time. Also in your manual is document checklists, like what you need for each application, and how to compile these things. So please, please, please look at your manuals. They're very comprehensive, and it does walk you through this process step by step. What to file in the I-45 packet, that's the adjustment of status application packet. It's going to be your Form G28. Payment of fee or Form I-912, which is a fee waiver request, okay? We have samples of all these forms in your manual, how to fill them out. There are some that are already annotated. There's some that are blank, but you will be able to see how to fill these out. If you have any questions on filling these forms out, contact your Justice mentor, okay? You will also need 2 passport photos. Passport photos are an issue right now during this pandemic and getting them. Again, there's an advisory in your manual about how to do this. I'm not going to go through it here because it's just going to take a lot of time, and we don't have that much time to finish the rest of this agenda. So just please read that manual, talk to your Her Justice mentor. Before you send anything, before you have your clients sign anything, you will be sending drafts of your the application to your Her Justice mentor, okay? I cannot reiterate that enough. Please send us drafts. Please send us and talk to your Her Justice mentor and ask them, how would you like us to do this? Okay, myself, I like it. You can send it to me. I understand that, there's pieces that happen. You might start her affidavit and that's going on, and somebody else might be doing the forms. It's okay. You don't have to compile the whole thing and send it to me, okay? You can send it to me in pieces. You can send me her first draft of her affidavit now, and then send me the forms later. But again, each of us has our own particular ways and styles of how we want it done. So talk to your Her Justice mentor. You will have an initial conversation with your Her Justice mentor before you call your client. After you review the case file, you're going to review that case file, and then you're going to contact your mentor and say, can we have a conversation? Okay, can we discuss this case? So then your mentor and you will talk about, okay, what you think might be issues, what they think might be issues, what they want you to focus on when you're doing that first interview with your client. We are a resource for you, so please, please, please utilize your Her Justice mentors as much as possible. And so you're going to have a lot of iterations back and forth, back and forth. Do not have your clients sign anything until you get the okay from your mentor. Do not sign anything yourself until you get with a fine tooth comb. I mean, I go over the forms question by question, and I will tell you on part 3, question 6, please answer this, or why does it say this? We have to discuss whatever it is. Okay, so we are very, very thorough and specific when we do these reviews. So please send us your documents for review before you send anything to USCIS. Okay. So what happens at USCIS action after filing? You will definitely get a receipt notice, or you should definitely get a receipt notice. If you don't get one within, about 6 weeks of filing, let your Her Justice mentor know, and there's a way to make sure that we track that down. So, and in terms of filing and mailing everything, make sure you mail it with some kind of trackable mail. We prefer FedEx or UPS, something that can get there for sure next day delivery. We have had some issues with registered mail. Even if you say next day delivery, it never really gets there next day delivery. So just make sure that you do something with trackable mail and track it. And if you get that delivery confirmation, take either a print screen of that, or print it out, okay? So you have it in your records to show USCIS later on. If they ever say, hey, you didn't meet this deadline, you can say, no, actually I did. It was delivered on this date to your office, and so signed for it, okay? So make sure you do track that. So after you file, what are you going to get? You're going to get a receipt notice for sure, and it will have an EAC. This is how you track it. And then the notice of approval or denial. Again, there's a general steps after filing document in your manual. It's pretty specific, so look at that. you might get a prima facie determination. To prima facie determination basically means USCIS has taken a cursory look at your client's application and has decided, yes, she meets like the criteria, okay, on its face. They have not looked at it deeper. They have not looked at it in for specific details. They're just looking at it just to make sure that you've hit all of the qualifications, and they're going to give you a prima facie determination. With this prima facie determination, your client can and is eligible for public benefits. Okay, some very limited public benefits such as emergency cash assistance, and Medicaid. Okay, in New York City, you might get request for further evidence. And I keep talking about this, like, make sure that when your initial filing is done so that you are going to avoid a request for further evidence, right? So the request for further evidence means, like, at the time they're adjudicating, if they're taking a deeper dive into your client's application and they find something is lacking, they're going to ask they're going to ask, hey, we need more information on a good faith marriage. You say this, but it doesn't photos, but what does that mean? It just means that you were at a time and a place, and that's it. So if you have photos, you want to explain the photos before, when you're sending it in. Say, oh, this is me and Joe at Pier 6. We went to Governor's Island together on this day. Whatever it is that the photo is. Describe the photo so that USCIS knows what it is and gives you more weight to that piece of evidence. You may get a notice of intent to deny after the RFE. Usually the notice of intent to deny comes after an RFE and you haven't still met that standard that they're looking for. So they might say, oh, well, we're going to deny you unless we get more information from you. Okay, so those are the things that may happen after filing. Look at the general steps again, and these are some practice tips. Follow your steps in the manual and use as a desk reference. Discuss your case with your mentor. Always send mentor drafts. I've already talked about all of this. Now, somebody asked me, what about if you get that denial, okay? And there was a time when I had like 10 slides on what to do after a denial. But I took those out because in this particular, training, we're not talking about denials. We are actually, Her Justice is contemplating, and we will be doing a standalone how to respond to RFEs, NOIDs, and denials at a future date. But for your purposes, I took all those out because it does take a long time and it kind of takes away from the initial filing, what you need to know for the initial filing. But your clients will ask you, what's going to happen if I get denied? Because there is a high probability, or there is not a high probability, but a heightened probability that your client may be denied and then given a notice to appear. Okay, so, and I say this now because, again, it's because the immigration landscape has changed. The immigration landscape has become so adversarial. Oh, I have to do another, I'm so sorry. Okay, I forgot to do this. I have to do another code. It's 4GT25. 4G as in gate, T as in Tom, 25. So 4GT25 for those of you who are listening to this later on or at home, or everybody's home though. Okay, so anyways, as I was saying, there was a time when USCIS, if you got your 360 denied, they didn't do anything about it. Okay, they said, okay, and they just left it, really. But nowadays, if you get it denied, they have said there were a flurry of policy changes and notices that went out in 2018 where they said a denial will result in a notice to appear. Now in immigration court in removal proceedings. Basically, they're saying, hey, your 360 was denied, you don't have status here, therefore we're going to try to remove you. However, doesn't mean they're going to remove you immediately, okay? The denial process takes a while. You get denied. Then what we do most of the time is we will file a 290B saying, no, USCIS, you are wrong in this, and we're making a motion to reopen and reconsider your decision because we believe we met the the elements of all of the VAWA self-petition process here. Okay, so, and then you're going to supplement her application. You're going to give more evidence. You're going to, or if they're wrong on the law, why are they wrong on the law? They said, oh, she didn't have enough good faith marriage. However, she did put in enough to say good faith marriage. Okay, so so the 290B process happens. Then if the 290B process is ultimately denied, then she's going to be put into, she may be put into removal proceedings. At that stage, you have one more chance to talk to the, to there was abuse during that marriage. Okay, so that's what you're going to prove. You're going to prove the same exact VAWA elements back with the in front of the immigration judge. Okay, so you have one more chance. So if your client says, "What if I get denied?" There's all these processes. She's not put on a plane the next day and sent home. Okay, now obviously, there are some caveats and exceptions to that, because if your client had a prior deportation order, okay, that's going to trigger some inadmissibility grounds, as well as if it is she is denied, she may not have a chance to get in front of an immigration judge, etc. Okay, so but those are few and far between in terms of this kind of application here. But if your client does have prior immigration violations and deportation orders, things like this, talk to your her justice mentor thoroughly, available to your client. Okay, so I hope I answered that question of like what happens if it's denied. Okay, any other questions so far in this, because we are moving into the I-751, the petition to remove conditions of residence or the hardship waivers. So nothing more on the I-360 piece, the VAWA self-petition, right? All right. I'm just going to check my time real quick. Okay, good. Okay, so we ask for the hardship waivers are because your client has conditional permanent residence. What does conditional permanent residence mean? That your client had an approved I-130 family-based petition, and they did the 485 with their spouse. And so they have the adjustment of status application and interview, and they got their green card. Okay, they got their green card. However, their marriage was less than 2 years. Okay, so this is what it is, right? You marry your client, you marry your spouse, and but before the marriage is 2 years old, your spouse applies for your residency. They say, oh, you know what? I'll do your green card, I'll do your immigration application for you, and everything's great, and you get your green card. However, the U.S. government only gives you a conditional residence for 2 years because your marriage was less than 2 years. Okay, why does this happen? Because U.S. government is very leery of marriage fraud. Again, remember the marriage fraud discussion from before. Same thing. They don't want people coming in here to say, oh, I will marry you. We will be married for, you will do my application. I will give you $10,000 and we'll be on our merry way. So they put this in here to say, you know what? If your marriage is less than 2 years old, we're going to give you a conditional residency. And then after 2 years is up, you need to remove those conditions. Okay. So let's look at Victoria's case again. So Sergey petitions for Victoria for a few months after their 2015 marriage, or did I say 2014? I don't know. Whenever they got married, after they got married, but before it was 2 years from the time of their marriage, he petitions for her. She receives a 2-year conditional resident card valid from January 1, 2016 to January 1, 2018, okay? So now she has a conditional card. So in a regular family-based application, what happens? A joint petition to remove conditions on residence based on ongoing marriage signed by both, filed 90 days prior to expiration. So be there with her to say after when the 2 years is up, but 90 days before 2 years is up, she needs to file the petition to remove her conditions with him. Okay, he has to sign the document as well and say, yes, we are still in a good relationship, and please approve this petition to remove conditions, so then I can have my 10-year green card, not just my 2-year conditional green card that expires. Okay. And it has to be filed 90 days prior. Okay, again, like I said. Then we have, however, in Victoria and Sergei's case, right, there was some abuse. We could prove that there was abuse. So what happens? She can file something called a hardship waiver based on good faith marriage and physical abuse or extreme cruelty during the marriage. Okay, so this is what we call the battered spouse waiver. On the I-751 form, there are reasons why you are filing to remove your conditions. It could be a joint filing. It could be I was married in good faith, but there was abuse or battery during the marriage. Or there's other hardship waivers based on there was a good faith marriage and I am divorced, or there was good faith marriage and if I didn't do this, the extreme hardship. There's going to be extreme hardship. I can't file with him because it poses an extreme hardship for me to file with my spouse. Okay, that extreme hardship doesn't have to be for the spouse. It could be an extreme hardship to yourself or your U.S. citizen child. Okay, is what you can show for the extreme hardship ground here. The other thing you could do it is, and it's not in here, the one other thing is there was a good faith marriage, but there was the death of the U.S. citizen petitioner. Okay, so this is all filed on Form I-751. This little call-out box here is where it says waiver of or individual filing request, and it will be E or F usually. And it's, I entered in good faith, and during the marriage I was battered or was the subject of extreme cruelty by my U.S. citizen or lawful permanent resident spouse. It's going to be E for most of our clients. However, if you are a child filing for I-751, you will be my parent, enter the marriage in good faith, and during the marriage I was battered or was subjected to extreme cruelty. Okay. Now, for derivatives on the I-751, remember in the I-360, the derivatives, you listed them in, and it didn't matter where they lived and if they had any kind of status, if they lived in the United States or not. Here it does matter. Okay, if you are a conditional resident and you have derivative children, if your derivative child also has conditional residency and they received this within 90 days of your client getting it, then this is a little bit confusing. Okay, so I'm gonna explain again in a minute, and if it's beyond 90 days, the child must file a separate I-751. Now, I'm gonna again explain that a little bit more clearly. So I am married to Amy. Amy has children. Okay, I'm married to Amy. Amy is my abusive spouse. I get my conditional residency. I have children. Okay, Amy concurrently filed for me and my children. Okay, to get our green cards. Okay, and my children and I all of us got our green cards at the same time. Now Amy abuses me. I need to get this conditional residency taken off. My children, since they got it at the same time I did, can be included in my application. Okay, but the other scenario is Amy applies for me. Okay, I get my conditional residency, and more than 90 days passes, maybe 3 or 6 months later, Amy says, oh, you know what, I'll do it for your kids. Your kids get it, my kids get it, but they got theirs 6 months after I did. They will have to file their own separate I-751 to remove those conditions, okay? And they could say it is because they are abused children. Remember, I was telling you category F of a U.S. citizen, okay? So, and even if it's a step-parent relationship, they can still be counted as children, even if they were not the actual, they weren't actually abused themselves, but they witnessed the abuse, you can put them in that category, okay? The harder part is if I have derivative children abroad Amy never applies for them, okay? That would mean I would have to do it later after I became a conditional resident, or I'm not a conditional resident, after I became a lawful permanent resident, or I could do it myself right now as a lawful permanent resident filing for children abroad, okay? So that's going to be the difference. If there are derivative children involved in your client's situation, talk to your Her Justice mentor about unpacking some of that and making sure you do it in the right category and so that they are captured properly, okay? Any questions on that? I know it was a little bit confusing. I'm trying to make it as basic as possible, but this is a little bit, just a little complicated because of the way the statute is written and how people fit into categories. Okay, so it's going to be the same kind of application, right? I mean, like the same kind of requirements are there. The elements are going to be the same. I'm not going to go through all of those again, but you're looking at good faith marriage. Same thing here. Good faith marriage that you looked at in the 360 application, it's going to be the same types of the evidence that you're going to be looking for, right? How they live together, you know, affidavits from your client, same thing. You're going to talk about it. You're going to talk about how they got married, what she felt for him, et cetera, like what they did, the nitty gritty details of their life together, right? That's how you're going to show that good faith marriage. Commingling of lives and finances. If you don't have something, why don't you have something? And then if there's children involved, you're going to say, yes, you know, we had children. This also shows good faith marriage here. And abuse, same thing. You're going to show why it was abusive, how it was abusive. Was it extreme cruelty? Was it physical battery? Same types of the requirements are the same. The only thing that's not required here for an I-751 that is required in an I-360 is the good moral character. You do not have to get that good moral character or certificate of conduct in an I-751 application. The rest of the things you do have to show, but this you don't. The good moral character is something you do not have to show, okay? So any questions regarding the gathering the evidence or the proof that you need? Because again, it is the same thing. You can scroll back up. I mean, you guys all will get the PowerPoint as well, or should have it. So just look back at the, you know, the requirements and how to get that requirement. Get those that evidence. And it is, again, the standard of proof is preponderance of the evidence with any credible relevant evidence. So if you want, you know, in your cover letters, you can say, this is more for an RFE, if you do get an RFE, is how you've met the preponderance of the evidence standard and how it is any credible relevant evidence and why you might not have primary evidence, okay, if you don't have something to prove it. Anything else? The other thing is that your client will still be subject to grounds of inadmissibility or removal here. She has her green card, but you know, the removal and or inadmissibility grounds are still relevant to her. So if she says, oh yeah, and the 751 will ask some of those questions as well. And if you have any yes answers, please talk to your Her Justice mentor. Okay. One thing I need to reiterate again is that make sure that you use all the updated versions of the forms. In our manual that you have a copy of now, there are copies of forms, and all the forms are there for you to look at. But make sure that you actually download the most updated, most recent version of that form from the uscis.gov website. They are updating forms all the time, and do not look at the expiration date of the form, because the expiration date of the form is on the top right hand corner. You need to look at the edition date of the form, which is on the bottom left hand. Expiration date, think, oh, it's not expired yet, but there might have been a change in that edition. So make sure that you look at the edition date, which is on the bottom left hand corner, and you use the most recent edition dates. And on the USCIS website, they tell you which edition dates they are accepting. So in the what are you going to file in an I-751 removal of conditions petition? You're going to file a cover letter, the Form G28, Again, all of this is in your manual with document assembly and document checklists. So take a look at that. I'm not going to read this whole slide here, but just for a quick reference is what you can look at as well. Okay, but please, please, please look at the manual again. Okay. Any questions on an I-751? No? Okay. The one thing that you do need to look at in an I-751 is your client's, the expiration date for that I-751. So if it was valid from January 1 to 20, like she just got it, right? So January 1, 2020, then she has until January 1, 2022 to actually file it. However, this can be filed at any time. It can be filed prior to that expiration, like before even the 90 days. The other one where you have to do a joint filing, it has to be within 90 days. You can't do it before 90 days. You can't do it after 90 days, okay? They want it within that 3-month window. They don't want it, so you can't remove your conditions before that 3-month window. Here, you can do it at any point. Say that your client got it January 1, 2020, and you're looking at it now, and you can file it in August of 2020 if you need, if you're all done with this, if you can actually compile all of her documents. What we do want what we recommend is everybody try to file it before the expiration of her conditional residency. So say that your client's conditional residency is expiring on, I don't know, September of 2020. Okay, September 1st, 2020. Please try to file this before September 1, 2020, because there is a policy, USCIS policy, is that if you do not file for your bad spouse waiver and or a waiver to remove those conditions, they will send you a notice to appear. Okay, so they'll refer you to immigration court, and then you will have to go to immigration court, tell the immigration court, no, we're filing this, please adjourn this, please put this on the status. It's just a whole other mess. So as much as possible, we encourage everybody to file their I-751s prior to that expiration of the conditional residency. Okay. Questions? Okay. And after filing, you will get a receipt notice like you did in the I-360 or the VAWA Self-Petition process, okay? But the difference here is you will get a receipt notice saying that they received it, and at the same time, it will be extending your client's conditional residence. They will say, okay, we received it, and we are extending the residency for a year during the pendency of this application. So while your client's application is pending, they're going to give her a receipt notice saying that it's been extended. Your client can take this receipt notice, and it's her green card. It's like, this is a proof of the extension of her green card status, her lawful permanent residency status. So if she wants to travel, she can still travel with that. If she's working, she can work with that. That's just proving that she's got status here, lawful permanent resident status. If what we have done in the past, and hopefully it will resume once USCIS opens again, their physical office is open here in the local office, is that you can actually get a stamp in her passport to show that her residency has been extended, and it will give the expiration date for the 1 year from the date of the receipt. Okay, so if she wants to travel, I mean, we highly recommend getting that stamp before traveling, because CBP is not so nice anymore, so they might give her problems coming in with just that piece of paper. Okay, but again, if that's the case, talk to your Her Justice mentor about getting an appointment at the local office to get that stamp. The other thing that you will get for sure, guaranteed, is a notice of approval or denial. Approval means, okay, your conditions have been removed, you are now a lawful permanent resident for 10 years, you're good to go, and she will get another green card that has the 10-year expiration, like the dates are going to be 10 years apart, okay? She might get a notice of denial. Denials work the same way as in an I-360 or I-45 denial. You're going to do a 290B to ask them to a motion to reopen or reconsider and say why they are incorrect in their decision of denial, okay? if you ever get a denial, it is a, and this goes for all denials across the board, you have 33 days in which to reply, okay? You need to reply within the 33 days, and for all, and we're gonna talk about a little bit about this in the best practices part, but for all immigration, it's not the date of mailing, but the date of receipt in their office, okay, is the deadline, okay? So you have to meet the deadline by actually them physically receiving it in their office. And it's not like, oh, I mailed it on the date that it expired. It's not gonna work. Of a denial, a motion to reopen or reconsider, or any kind of deadlines that you might have, like a derivative aging out, things like this. So you have to have it received in their office by that deadline date. Your client might get an RFE, a request for further evidence. USCIS has looked at your application. If they think something is lacking, they will ask you for certain things. They will say, oh, we don't see this, we think this. When you get an RFE, NOID, anything like this, talk to your Her Justice mentor, because the RFEs are sometimes wrong. They're asking for certain things that are not pertinent to your application. They've gotten the facts wrong. They're saying certain things that are not necessary. They're saying, oh, you need good moral character here. You don't need good moral character, whatever it is for a 751. So once you get that RFE, please talk to your Her Justice mentor, or your Her Justice mentor will go through that RFE with you line by line to say how you're going to respond to it, what evidence that you're going to get to supplement that. So please, if you do get an RFE or a NOID, which is a notice of intent to deny, or NOIR, which is a notice of intent to revoke, any of those kinds of not totally negative, but a little negative decision or a request, please talk to your Her Justice mentor immediately, okay? The other thing that you might get an interview, okay? It's not even a might these days. It is, you probably will be, your client will be interviewed for, to take those conditions off. They've, USCIS Vermont Service Center will have looked at it, then they will send it to the local office. The local office will most likely send an interview notice to say, okay, come in for an interview. Your client will go in. They're just going to look at, just to make sure that everything she said in the application is still correct, and that there was no fraud or misrepresentation done in that application, okay? The thing to note about a 751 is that there is a prior application that is existing, right? Because he filed I-130, he filed the I-485. So what you need to do, as much as possible, if possible, is to ask her to get her hands on that initial previous filing, because something may have gone wrong in that initial previous filing. And you're gonna say all this stuff, and it's gonna totally be counter to what was already filed, okay? So your client's credibility is now at question. So you do want to make sure that you try to get your hands on that previous filing. And this also goes for the 360 or 485. If there was any previous immigration filing done, and immigration, there is an A file, we call it an A file, with immigration on your client's behalf, make sure that you try to get your hands on that. You can do that by, if she used a former attorney, you can see if she can get those documents, a copy of those documents from her former attorney. The harder ones are when they do a pro se with just their husbands or their spouses, and they file something. And so if that's the case, just asking for it from a previous attorney, or she doesn't have copies of it, you can do something called the FOIA request, which is the Freedom of Information Act request. And this is done to USCIS, CBP, and the immigration court. So depending on your client's immigration history, you will need to get that. You should get a copy of the FOIA. You should do a FOIA request and get a copy of her filing, okay? Your case opening reports will have said something about FOIAs, most likely. All of us, when we do our intakes and our assessments of our clients, we will write those up in our case opening reports about what next steps are necessary. And if we have done the FOIA ourselves, it will be written in there, okay? So just make sure if there is any mention of a FOIA, you do talk to your Her Justice mentor about that. Or if in the course of your representation of your client, she says, oh yeah, by the way, I forgot to tell the Her Justice person this, but this other thing came in and I was like a beneficiary on somebody else's application. And if that's the case, make sure that you do get that file. Okay. Other things about best practices, communicating with USCIS, you can check your current processing times online here. Check the current processing times. And this is for your edification as well as for your client's edification, right? Your clients are going to want to know, okay, you filed this, how long is it taking? Look at the case processing times and say, oh, it looks like they are adjudicating cases. They're like about 18 months out. So we won't probably get any kind of information for another year and a half. In the meantime, please make sure that you stay in touch with me. Anything happens, let me know. You know, any life-changing events, like you had a baby, you're getting married, whatever it is, right? You get arrested. Arrests are huge, so make sure that they do get in touch with you if anything happens to them. Okay, not that you're going to become their criminal defense attorney, not that you're going to become their divorce attorney or anything like that, but things will come up. Ask them to get in touch with you, and if something like that does come up, get in touch. Then you in turn will get in touch with your Her Justice mentor and talk about those what ramifications those actions might have on your client's pending case. Okay, so make sure that you do look up at the current processing times to give your client updates, and then also sign up for case updates yourself. Once you get that the receipt notice, you will have an EAC number, and you can actually go online to USCIS and sign up for your for case updates. You will put that EAC number in there. And the good thing about this is that if there is any movement on your client's case, they will send you an email saying, you will get an email alert saying that a notice was sent out, something was sent out. So you can be on the alert to think, okay, this should come to my office by X date. And from USCIS, it's gonna be in my client's name. My client's name is X, because what USCIS does is they don't necessarily put your name in that box as a CO. They will say Maria Lopez, Sherman and Sterling, okay? And there might not be a Maria Lopez associate who works at Sherman and Sterling, and so your mailroom ends up then just sending it back, okay, to USCIS as undeliverable. USCIS now has it. They send you a notice saying that this was undeliverable, and it was your client's, maybe her employment authorization, right? Whatever it is. So make sure you do tell your mailroom and or your managing attorney's office or your pro bono counsel's office, whoever it is, your pro bono partner's office, whatever it is, the list of clients that you may be getting mail for, physical mail in your mailroom, so that your mailroom people know this, okay? It's really, really important because mail gets lost all the time in the large law firms. And it's no fault of anybody's, except for that USCIS just doesn't always put in the CO to the attorney in there. We had a case where the employment authorization got sent back twice because the associate was looking for it. She knew that something was coming, but she went to look for it. It had already made its rounds, and the managing attorney's office had sent it back because they didn't know who this person was. So again, just make sure that you do alert whoever it needs to be, that needs to be alerted that this is a mail that will come in somebody else's name, but it should be directed to you, okay? I went through this again. Send all applications to USCIS through trackable mail. And then the mailroom alert, okay? Mail getting lost is a huge thing. And unfortunately, USCIS, if they send you a piece of, like a denial notice and or an RFE notice, and you don't respond because you never got it, they're gonna send you, but they, in their records, it says that you received it. They won't, they say, well, prove to us you never got it. Well, how do you prove to them that, how do you prove the negative? And basically that's what they're asking you to do. So just make sure that the mail does get routed properly, because once, if it gets lost, it just becomes another big headache, okay? How do you communicate with USCIS? After you file your application, your G28 is on file. You can, and you need to talk to USCIS for whatever reason. These are the email addresses: hotline follow-up i360.bsc@uscis.dhs.gov, and then for the 51. Now, these emails are regularly responded to, but not readily responded to, okay? So okay, they will usually take about I don't know, 2 weeks usually, sometimes a month to respond to you. And they will tell you how long they are taking to respond, okay? When you do email them, you're going to put a copy of your G28, your client's A number, and the receipt number, and then you're going to say what it is you are emailing them about, okay? If it is just a regular case processing update, do not email them. You will email them if it's the case is outside of processing times. You're supposed to get that EAD for the client, and it's been now 8 months since you filed it, and case processing times, it says it's only going to be 4 months until she gets it. Again, that's when you're going to email them. The other thing you could do is you can also call them and leave them a message. This is a voicemail line. And they tell you, like, they will give you a call back in within 5 business days, okay? In the past, they have told us, do not email and call at the same time. Do one or the other, because there's one A file, and if one officer pulls it, and then the person who's going to answer you by email pulls it, and then you call on the phone, and then the person who's going to answer you on the phone is not going to be the same person, they're going to have to take time to find that A file. So they have told us don't do both at the same time. However, recently they have been unresponsive in a lot of cases, so people have been doing both and getting at least a response from one or the other. Okay, so talk to her justice mentor about the best way to contact USCIS if that is necessary. The other thing you could do is call the USCIS contact center, and this is the information here. And it used to be called the national hotline number or customer service number, but they've now changed it to contact center, because they have done away with InfoPass, meaning that you cannot just go to the local office to ask for, to inquire about your case. They want you, everything gets routed first to this contact center before you can call the local office or other offices. But however, for you, the VAWA self-petitions and battered spouse waivers, you got to call the USCIS and Vermont Service Center first, okay? If you call the contact center, there's a flag on your client's petition that will say they can't talk to you because of confidentiality reasons. Remember way back in the beginning of this presentation when I was saying that there are confidentiality protections here, and that's one of them. It's like not just and they won't just give information to anybody if you just call the contact center regarding your client's case. So you might call the contact center. They will tell you, yes, we have her in the system. However, there's a flag here that says I can't talk to you. You got to call the Vermont Service Center. Okay, so that's when you're gonna go back to the Vermont Service Center. But if that happens, talk to your justice mentor. We'll talk about how. Okay. Any questions about communicating with USCIS? Okay. Then you're going to communicate with us. Again, like I said, send your mentor drafts of all the forms, affidavits, cover letters, and indices of evidence. We will tell you what we are missing, what we have not seen. If you send me XYZ but not A, I will say, hey, I didn't see A. Can you please also send that? Have you been drafting that, etc. When you send things to us, allow 3 to 5 days for turnaround time. We try to get to these as quickly as possible, but again, we are mentoring. Each of us has about like 10 cases for the summer. So note that, we are juggling our time with other your application with other applications as well, and trying to divide our time, as well as, we still continue to get intakes for new clients too. So give your mentor about 3 to 5 day turnaround time, but make sure that your mentor does acknowledge that they got it, right? That they do send you a quick email saying, yes, I got it. I'll get back to you on this. Okay. If you do not hear back from your mentor within 3 to 5 days, it's okay to nudge us again. Ping us, whatever, email us and just say, just making sure you got it, or inquiring about the below. Please let us know, okay? It's not that we're ignoring you. It may have fallen through, what have you. So just make sure that we do get it, okay? And then once you're done, your application is totally complete, right? Make sure you make a copy for yourself, for your file, make a copy for your client, and then make a PDF copy for her justice and send it to your mentor so we can put it into our system. And we like to have the filed application, because just in case, if you leave the firm or something happens to the application, whatever, and somebody else takes over for it, we need to know what was filed, and it's easier if we also have it in addition to the firm having it. Okay, so make sure you do send a copy to your Her Justice mentor, whatever it is that gets filed. And also it helps us later on if you do get an RFE or if you get a NOID or a denial, just to say, okay, like, let's see what was filed and we're going to supplement that. Okay. Any questions? Okay, so communicating with us, like I said, after you review your training manual and case file, you call us before you meet with your client, right? And then you're going to call us again and talk to us about things that may have happened or come up after you meet with your client. Maybe like you and I talked about, okay, these are the issues that you might see. And then you meet with your client, and then what are we going to do? And or you say, oh, you know what, she told me XYZ, how should we do this? So call your mentor whenever something comes up. We are here, again, readily available for you. You can email us, you can call us. You're going to call us again if you get any notices from USCIS, good, bad, receipt notices, whatever it is. It could be just, and for receiving any USCIS notices, you can, if it's just a receipt notice, you can send it by email saying, hey, we got this. If it's if it's more of a, on the more negative end of an RFE, NOID, or a denial, you usually will have you'll send it to us, and then we'll schedule a time to talk on the telephone to actually talk about how to respond to these things. Okay. Again, here it is. Immediately contact your mentor if you get an RFE or a NOID, if your case is outside of processing times, or if your client is arrested. If you're going to leave the firm, please let us know so we know who the new person is, and we know to make sure that it is restaffed. Okay, so make sure you do let us know these things, and then contact us immediately. The RFEs, NOIDs, and denials all have deadlines. The RFE, you have 87 days to respond to an RFE. You have 33 days to respond to a NOID. You have 33 days to respond to a denial. So make sure that you you get in touch with your Her Justice mentor immediately so that you can meet those filing deadlines. Okay. I want that one. Communicating with your client. I cannot emphasize this enough. You need to make sure that your client knows how to get in touch with you, especially during this time, right? A lot of you are working from home. I do not recommend that you give your client your cell phone number, okay? Make sure that your phone gets routed properly to your work phone is being routed properly so that your client can call you if they need to, okay? But I really discourage any of you from giving your cell phone numbers out. It's always good to keep that distance from your client, so just make sure that your tech is up, and if it's not, talk to your firm tech department about what you need to be able to do this, to work with your client, okay, during this time. And then obviously you're going to tell your client, hey, call me whenever XYZ thing happens. So I've been reiterating this over and over again. Any kind of life-changing thing that happens, please make sure that you have your client call you and let you know. Also, make a calendar invite. These are taking, not a calendar, right? A calendar reminder. These applications are taking a long time to adjudicate. So put a calendar reminder in your calendar, 4 months or 6, anywhere between 4 and 6 months. Call Maria, and she hasn't moved, that she hasn't moved out of state, things like this, okay? And obviously you're going to reassure your client of confidentiality. Again, if working with an interpreter, there is a whole section about working with interpreters in your manual, so please look at that if you are going to be using an interpreter to communicate with your client, okay? And then here is some resources, your online resources, and then your offline resources. This is going to be your most important, is going to be your Her Justice training manual. Again, use this as a desk reference, keep it near you. It is the step-by-step case guidance of, there's everything in there from checklists to sample, affidavits, sample everything. So, and if you find that there's something lacking, please let us know so we can add it for the next training. And I'm sure if it's lacking, if it's not in here, we do have it in our samples elsewhere or with other client documents that we can redact and send to you. So if it's something that you really think you do need and we don't have it here, just let us know, okay? The last slide here is on our offline resources. I mean, again, is us, right? Your Her Justice mentors. Your Her Justice mentor, you will know who that person is in your case opening report. It will say your Her Justice mentor is so-and-so, and this is how you get in touch with them, okay? It's Pratibha, Tim, me, or Susanna. So, and if one of us is not available, somebody else is not available, we always have coverage, and we will tell you who that person is that is covering for us at that time, okay? And we are done. Any questions? Questions? No questions.
None so far. So now is the end of the presentation. So if you have any questions, definitely please submit them now via the Q&A feature, or if you cannot get the Q&A feature to work, you are welcome to use chat. But again, we prefer Q&A.
Okay. Well, if there are no questions, this is the end. Thank you for sitting through this 2.5 hour presentation with me. I hope you guys learned a lot. There are, if you have other specific questions that I did not cover, feel free to email me or call me, and I will, be sure to answer those questions as well. Like I said, this is new to us in terms of the webinar, so there might be things that I may have gone too fast over or not been able to give you a whole lot of information on. So if you do have any other questions that do come up as you're working on your cases, talk to your Her Justice mentor, or you can call me as well, and we are here for you. Okay. So I hope everybody stays well, healthy, safe, and we will be in touch. Okay. Thank you.
Thank you all. I have a question here for me. Do summer associates need to fill out the volunteer info survey at the end of the presentation if we haven't started the program and don't know our supervising attorneys? I would say yes, please fill out the surveys regardless. Esther, do you have a preference on this?
It would be good to fill them out. If you just fill out as much as you can. If you don't know who your supervising attorney is, that's okay. Leave those blank, because that'll actually be helpful for us to inform our pro bono management department that is in touch with your firms to say, okay, can you guys tell us who who's going to be on these cases? Okay, so it's fine if you don't know who your case, what case you're working on, and or who your supervising attorney is. Just fill in as much as you can, and that will help us to be able to follow up with the firms as well. So yeah, good question, and thank you.
All right. I think that's it, unless anyone else has any other questions.
Okay.
All right. Thank you all so much. Again, please fill out the surveys that you were directed to, as we just went over. Please fill those out the best you can. And thank you all so much for getting involved, especially those of you who are working on cases. Now is a really difficult time for our clients, and just in general trying to get any kind of services for our clients, let alone legal services. So your help is extremely valuable, and we value it, and we know that they value it. So again, thank you for getting involved through this program. So yeah, without that, like I said, as Esther said, if you have any questions about your cases or legal questions, please reach out to her or any of the mentors. If you have questions about CLE or anything else training related, please reach out to me. And I think that's it. Thank you all so much, and have a great rest of the day.
Oh, wait, last code. I'm so sorry.
Oh yeah, because we're right at the 50 minutes.
Yes, we're at the 50 minutes. AAJ99. So it's AAJ99.
And that is the third code. Yes.
That is the third code. Okay.
All right. I think
have a great weekend, all.
Thank you so much. Have a great weekend, and take care of yourselves.